Well, it really is a pleasure to be here. Save Our Shoreline is about 3,000 shoreline owners up in Michigan, so we're a lot like you. We're not nearly as big as you. I'm really impressed with that 7,000 number based on how many folks you have on Lake Erie, and I think you ought to talk about that a little bit more. It's a big number. Right now, your group is you've had a substantial victory, and we really applaud you. You've won in the county court, you've won in the Court of Appeals, but your real battle is coming here in front of the Ohio Supreme Court. And that's because the Ohio Supreme Court, unlike those other two courts, has the power to further define the law, and it has the power to change the law. Your Court of Appeals had to follow the law. And in Michigan, that's where we found that there was a substantial problem. Tonight, I'd like to share with you our experience up in Michigan and maybe give you some recommendations from what we did where we think we could have done better. And I want to talk about the case of Glass versus Geckel. It was a fight between the Geckels, who owned shoreline property on Lake Huron up near Alpena, and they were opposing Mrs. Glass, who was a backlotter, and she wanted the right to use their beach. And she is the one that filed the lawsuit to use their beach, and of course the public didn't report that, the press didn't report that very widely. She filed the lawsuit to use their beach, and of course they had to oppose that lawsuit. But Michigan law was clear at the time. I think they had a good reason to continue to fight. The law was clear. They owned to the water's edge, and they had exclusive use rights. And the case made it all the way to the Michigan Supreme Court. And we were virtually certain we were going to win that case. Tony? But in Glass versus Geckel, the Michigan Supreme Court changed the law. And they did this while saying they weren't changing the law. What they did is they took away the owner's exclusive use and they created a right of beach walking. How they did it? Well, they said that exclusive use rights never existed in Michigan. And they said that beach walking rights always existed in Michigan. But that's about all they could do, was say it, because they didn't have much in the way of proof. And one of the main problems I have with that case in Michigan is that they completely ignored the precedent that that very court had set a century before. All throughout the 20th century, it was clear in Michigan that we owned to the water's edge and that we had exclusive use rights. And I want to share some of that law with you. That's what we're going to be doing next. The first quote is from Hilt versus Weber. That's our landmark case in Michigan. It's a 1930 case. And in that case, the Michigan Supreme Court said the riparian owner has exclusive use of the bank and shore. Exclusive use. That's just the same thing that the court in Glass said we didn't have. They said that we did have it in 1930. And there's two other cases, if you can go back to that other slide. Can we do that? There's two other cases. We started out with a 1930 case, then we had a 1937 case, and then we had a case in 1994. So we spanned a good part of that century with very clear law. The riparian owner had exclusive use of the bank and shore. Okay. And so the Michigan Attorney Generals were asked several times to determine or to state what the law was. And so we have several Attorney General opinions, and I'm going to share some of those with you. First one's from 1933, and it says, the riparian title on the Great Lakes goes to the water at whatever stage, the shore being subject to the public use when it becomes covered with water. So the only time the public got to use the beach back in 1933, according to the Michigan Attorney General, was when it was covered with water, just like we were talking about here earlier. Okay. 1944, the Attorney General said lands formerly submerged would become by religion lands owned and controlled by the riparian owner. So when the land was dry, it became controlled by the riparian owner. And the next Attorney General opinion helps us understand what that means. The riparian in 1978, the Attorney General said, the riparian therefore has trespass control to the water's edge. So we have all these court cases And now we have all these Michigan Attorney General opinions saying we have exclusive use. And the fact that the Michigan Attorney General said that we had exclusive use several times in the 20th century, I think is important, because the Michigan Attorney General is the top law enforcement officer in Michigan, and he's also basically the lawyer for our state departments, like, say, the Department of State Police, the Environmental Department, and our Department of Conservation. He's the one advising them. And so when he, top law enforcement officer, says that we own to the water's edge and that we have exclusive use, that certainly has to mean something over a century. Okay. So the law was so clear that when the Michigan Court of Appeals was asked to look at it in Glass versus Geckel, they said riparian owners have the right to the exclusive use and enjoyment of their land to the water's edge. And the important point here is what I shared with you earlier. The Court of Appeals, they're the lower court. They have to follow the law. And that's what they did. Okay, we were really confident. We were so confident that we drafted this newsletter thinking we were going to win this lawsuit. But that never went out. And the reason I share that with you is I think this group can't be overconfident about what's going to happen in the Ohio Supreme Court, even though we have victories below. This is a big, big battle that you folks are facing, and we don't want you to be overconfident like we were with this newsletter. Because here's what happened to us in this Michigan Supreme Court. All those things I said about exclusive use, here's what they said. We cannot leave uncorrected the Court of Appeals award to littoral landowners of a right to exclusive use down to the water's edge. It upset the balance between private title and public rights along our Great Lakes and disrupted a previously quiet status quo. It's just outrageous. That statement from the court is just outrageous, and I'm going to show you how outrageous it is. Every time I read that decision, that's the way I feel, even 5 years later. It's hard for me to come and talk to groups like this about that decision, because that's all it does to me. Every time I read it, the law is, it just doesn't make sense what they did. It's a result-oriented opinion, and they just didn't pay attention to their prior law. I read a passage today which totally misrepresented what the Hill Court said, but apparently that's what's going on in the Michigan Supreme Court on this decision. It just makes me very angry. So, next. I wasn't the only one that was really surprised by that decision. The Associated Press said the decision surprised many, including those who got the result they wanted. And you're going to love this next slide. Even the lawyer for the winner, Pamela Burt, the attorney for Mrs. Glass, said never in a million years did she think the Walker's cause would get the support among the justices that it did. Never in a million years did she think she was going to win that case. That's how clear the law was in Michigan. And this is just sort of highlighting what I just went through with you. We got all these authorities on one side saying we had exclusive use, and we got the Michigan Supreme Court there on the other side saying, nope, there's a right of beach walking. Okay. So we had to send out this newsletter. State High Court takes our beaches, but SOS Board vows to fight on. Now, I want to be clear about that. The court actually never decided who owned beaches. I assume the court's going to decide that in this case because it's an important thing that has to be decided. But they got away in our case with just talking about this right of beach walking. They basically said, we don't care who owns the beaches. It doesn't matter because there's a public trust right to walk the beach.